Item number 18, Mr. Previn. Yeah. Oh, goodness. Cold back again. Okay, we'll call her last. Okay, Keith Shannon, or Shannon Keith, Mr. Previn, Jill Ryther, Michael Roston. Yeah, 1 minute each, please.
1 minute.
Okay, whoever wants to go first.
I can't. I have documents for each of you.
Okay, he'll pass it out to us.
I have documents as well.
Okay, we'll get them.
Want to go first?
Sure.
Oh, okay. My name is Michael Rodston. I'm an animal lawyer, so to say. I've been doing animal law for 20 years, and I've done a lot of dangerous dog cases, including with and against the department in Los Angeles County. I'd like to comment, and I won't have enough time, so I'm going to have to race through, but I gave you an outline of specific details of what's wrong with each portion of the amendment that they're seeking to change. But their general comments in their analysis needs mention. They're saying there's 3 basic problems. First, having an administrative hearing option instead of just having a court option. And what's basically wrong with that is when there's a judge hearing a case, it's much more fair and impartial to the department as well as the dog owner. But to turn the decision-making over to the administrative portion of the animal control department is self-serving and very biased. And most every time I do these animal control hearings, if it's done by an animal control officer, it's very slanted. Okay. Then they also want to change severe injury and include that which would be under potentially dangerous. Okay. And what in effect they're doing is upgrading conduct on the part of a dog, and that should be left alone.
Thank you. Thank you. Yes, ma'am.
Hi, my name is Jill Ryther. I'm also an attorney here in Los Angeles. I think there's a lot of things wrong with the amendment to Title 10, but there's just 2 I want to comment on briefly from a legal perspective. And the first is the amendment's detrimental vagueness. I've learned as an attorney that in law it's critical to be precise. We have definitions written into our laws, and then we have them codified through case law. And the reason we do that is because when our laws aren't understandable and easy to apply, citizens' rights are at risk. And this is true in all areas of law. And the problem when language is vague and overbroad is that it's ripe for abuse, and it results in unintended and devastating consequences that go well beyond the intent and the scope of the law in the first place. So for example, with the current proposed amendment, they try to broaden the scope of severe injury to include any physical harm to a human and even an illness. So in the Director of Animal Control's own words, it doesn't even have to be a bite. It could be somebody running from a dog who gets injured on their own, and then this dog could be potentially dangerous. This is a prime example of why vague statutes are so problematic. And additionally, there's absolutely no due process allowed in the current amendment. Okay. Because they're allowing their own employee to serve as the administrative officer, and it's ludicrous to believe that they can be completely unbiased when they obviously have loyalty to colleagues and to their employer.
Thank you. Thank you. Yes, ma'am.
Hi. Good afternoon. Thank you for hearing me. My name is Shannon Keith. I'm also an animal rights attorney, and I've been doing dangerous dog cases in LA City and LA County for over 13 years now. I did pass around a letter signed by other attorneys, and a behaviorist is going to speak. And I'd also like to acknowledge that we put together an online petition, and I have a copy here of all the signatories as of 6 a.m. this morning. Here you go. There were over 1,725 signatures in opposition to the proposed amendments. I'd like to say that the DACC has presented absolutely no evidence that the present system is inadequate to deal with potentially dangerous or vicious dogs, leaving the public at risk of harm from such animals. In all of my years defending potentially dangerous and vicious dogs, I've never ever had a repeat offender. The system is already confusing enough as it is, vague enough as it is. And while I could criticize the current state of the ordinance and procedures, I would much rather have us keep the status quo rather than passively allowing these new amendments to go forward where lives are at stake. Not only do I oppose the suggested overbroad, vague changes of the term severe injury, but I also oppose labeling a dog as potentially dangerous or vicious when determined as such in another jurisdiction. I've represented people in other jurisdictions where their dogs were labeled potentially dangerous and vicious, and these ordinances were completely unconstitutional. In fact, in San Jose, one of them didn't even afford notice or hearing. That opens up the floodgates to leave LA County ripe for lawsuits.
Thank you. Thank you. Robert Carball, Kevin Booth,
Mr. Antonich,
and Allison Richards.
Mr. Booth had to leave due to the extension
he's not
of
here.
time.
I'm sorry.
No, but Mr. Roxton will take his time because he's a
No,
part
you
of the
can't do that. I'm
Well,
sorry.
we would like to request that he finish his remarks.
Sorry, sir.
Okay, just to be clear.
Mr. Robert Carball,
Yes,
Mr. Booth is not, okay, and then Eric is here. Is Allison Richards here? Allison? Okay. And Richard McClellan. Okay, Richard McClellan. Okay, Mr. Previn, your turn.
Yeah, I will take 2 minutes as the other individuals in this board were able to
You'll
address.
take
My name
1
is
minute for yourself.
Yeah, my name is Eric Previn, and I am the county resident from District 3, and I completely oppose this ordinance these ordinance amendments. For one, a animal control officer playing the role of judge and jury over their own evidence is completely absurd and not in the interest of due process of our residents. This particular proposed amendment that would require that has been put together by a county councilor who has been personally herself named in a lawsuit that for not failing to provide a hearing at all, and then for retaliating with the animal control trucks afterwards. When I brought this to this very board's attention in front of Mr. Yaroslavsky, they said, we will respond, and they sent the animal control trucks out after an egregious 6-month incarceration of our dogs who are family members to us. This is not a surprise to any of you. This ordinance was introduced last Tuesday. There are over almost 2,000 individuals who have come out in signature to say that this is wrong, and for this board to push it through is a terrifying and depressing story for this county. We must stand together and remember that the county's role here is to defend the residents, not to defend the agencies that work here under our scheme.
We pay Thank you.
For people.
Thank you. Okay. Yes, ma'am. Your time is up, sir. Hi.
Richards, and I am a Los Angeles resident, and I'm asking you, I'm strongly urging you to reject the amendment to Title 10. As a dog owner here in LA, I can just simply say that this is terrifying. I have a 125-pound gentle giant dog, but by the sheer size, obviously there are people who could think she's, frightening. She is the friendliest, nicest, most cuddly dog on the planet, but if a child decides that her size is frightening and decides to run away and trips and falls, and all of a sudden my dog is exposed to, all of the new amendments that would take place if this were to pass. That's a terrifying thing for a dog owner to be subjected to. Additionally, as it stands right now, a hearing notice would be sent to a dog owner that pertains to the fact that there's going to be a hearing on to conclude whether a dog is dangerous or not. Under the new amendment, this would require no receipt of return that somebody actually got that notice. So I think that, in addition to everything else, puts the dog owner at even more risk. It's a scary, scary amendment to pass. Please don't pass it.
The proposed ordinance before us today classifies all dogs as potentially dangerous without taking into account a dog's natural core drive, instincts, and paints all dogs with a broad stroke of potentially dangerous and will serve to put even our friendly family dogs at risk of death. My name is Robert Cabral. I'm a behaviorist here in Los Angeles and the founder of BoundAngels.org. My primary focus is the evaluation and rehabilitation of dogs deemed potentially dangerous, and vicious. I've worked with hundreds of dogs in city, county, and private shelters. My work has proven countless times that dogs deemed dangerous are oftentimes misunderstood, and after clear and fair evaluations, I've placed many of these dogs into loving family homes without incident. As a person who works almost exclusively with shelter pets and dogs classified by municipal shelters as dangerous, I can tell you that the criteria by which shelter staff judges and classifies these animals is at best inconclusive and more often than not absolutely contrary to the core instincts which are hardwired into the brain of the dog. I've seen countless times where harmless dogs were considered dangerous and cases in which dogs labeled harmless truly were dangerous. While dogs' natural instincts are to chase, to play, and to bite, Marcia Maida stated that in a CBS interview that a dog charging you down the street could be labeled potentially dangerous. Really? Is that really going to be dangerous? Is every dog that barks going to bite? We need to have a clear definition. I'd like to say from the dog standpoint, we need to be fair.
Thank you.
Thank you.
Let me also call up Melissa Carbone and Pat Dinsmore. Yes.
Yes, my question to the board is this necessary as an amendment, or is this expediency? I would just like to direct your attention to the case of Michael Vick, who had a large number of fighting dogs. And those dogs were turned over to an animal rights shelter. Those dogs were rehabilitated. Those dogs are all now in the hands of loving families. So what our concept of as a dangerous dog may just be the fact that we have a horrific companion animal overpopulation problem. We have that because of the unwillingness of our decision makers for the last 80 years to deal effectively with this overpopulation problem. It's crowded our shelters. It's created a fiduciary burden upon the taxpayers of this community. And in my opinion, it is because decision makers have been unwilling to listen to scientific, coherent arguments about how to eliminate this problem. They have trivialized it for 80 years.
Thank you, sir. Yes, ma'am.
And part-time rescuer. I adopted a female adult pit bull from Pasadena Humane. She had failed her temperament test and was scheduled to be euthanized, but I talked them into letting me adopt her, and she is now a certified therapy dog. I would entrust my life with this dog, with any person, baby. She's a wonderful dog, and pit bulls are so, you're able to rehabilitate them easier than I think any other breed. I've seen dogs that have been burned and beaten come back and just be loving pets, and so I think this just adds into the fear and hysteria of the breed, and I urge you to not enact this. Thank you.
Thank you. Yes, ma'am.
Good afternoon. It's disappointing that taxpayer funds have been used to develop, promote, and potentially enforce a new law like this. Considering the current budget constraints have resulted in less animal welfare services and more killing in our government-funded shelters. This expanded definition only grants further arbitrary power to our government shelter staff to impose killing without sufficient due process for dog owners. Thank you.
Thank you. Nicole Pearson in the Antelope Valley. Nicole. Okay. Hi.
My new formula, it's for the waste, fraud, and abuse type thing. So it goes like for the last 12 years or the last 13 years, we go back and we check to see. But definitely 25 years, because you know how the major services, the contracts or the evergreen services, they're 25 years. We grant for 25 years. So we go back and we check to find out all the grievances. And then when we find the grievances, then basically say, okay, it's our fault. And then go to the codes and go to the codes. I don't have the paper. Go to the codes and basically say, okay, well, if it was our fault, what in the code was wrong, or what did we do wrong? Okay, because I don't know, you can either call me like really dumb or really stupid, but it shouldn't take like someone like 3 or 8 years to figure out, something in the code. Just say like my Sadie dog, I went to go get her at the shelter, and then, well, how come, like 8 or like 3, 5 years ago,
Thank you, Nicole.
I went to go get her at the shelter.
Okay, dear. Thank you.
Okay.
Okay, bye-bye. Okay, Marcia, could you just give a little genesis on the proposal that's before us today?
Yes, thank you, Mr. Mayor and Supervisors.
We're recommending the administrative hearing process be added to the current ordinance because number one, it's been permitted by state law for over 10 years, longer. It's a well-established and commonly used means of hearing potentially dangerous and vicious dog cases, and it's a cost-effective solution for these cases for the County of Los Angeles as well as the dog owners, because there's less costs associated with an administrative hearing process rather than going to court. The dog owners still may appeal a decision from an administrative hearing to Superior Court as well as the department, and they will have the opportunity to be heard again. And we feel that it's just a very effective, cost-effective, legal, well-established process to have in place that has been used commonly by many other animal control jurisdictions in the state. We feel it would be a benefit to Los Angeles County as well.
And the reason for this is because of?
We've been planning to introduce or recommend this for well over a year. We had to table it for a while we were working on the commercial breeding operation ordinance. Once that was completed, we were able to bring this forward because we saw the cost to the county and as well as the taxpayers who are there because of their animal. We just feel this is just a much more effective process for everybody.
Okay. So we have a, sorry, sir. So we have a motion to approve by Supervisor Molina, seconded without objection, so ordered. Thank you. Thank you, Marshall.
I just want to say there were many Public Record Act requests. You gave me 1 minute so I couldn't say it.
Thank you. Thank you. Sign up under public comment to this.
Okay, I'll make it a public comment record. We'll direct the people to look at that. But you must understand, this is travesty. Okay? Just so we're clear, this is mine. She didn't address it. She answered your fed question.
Okay, speak under public comment and you can express those views, Mr. Previn.
No public hearing on this matter.
Okay. Please, under public comment, you can make those points.